to Crime in Court. This is the state's case, part 41 in California versus Erik and Lyle Menendez in their 1996 trial for the homicides of their parents, Kitty and Jose. We are almost through with the state's case. We have this guy on the stand for a few days. Ugh, it's kind of rough to get through, but we're getting through it. He is Dr. Roger McCarthy, the mechanical engineer, not the biomechanical engineer. So I don't know what he's doing in this trial, but he is, I guess, testifying to the trajectory and the angles and things with the bullets, the shots. However, uh, Ms. Erickson is doing a pretty good job, I think, kind of discrediting him. Um, So let's continue. She is still in the middle of cross examination with him. And please hit the like button. And oops, let me move the screen over a little bit. There you go. All right. So we are starting with November 15th, 1995. The court says everybody is present and we're ready to proceed. So let's get the jury out. Miss Abramson says, Your Honor, I do apologize. I was a little late this morning, which slowed things down. The jury then enters the room and the following proceedings were held. The court says, and the jury is in the court. Good morning to all. We are ready to resume with the trial. The witness is on the witness stand. Would you say your name again for us, please? Witness says, Roger Lee McCarthy. Court says, I will remind you, you are still under oath. The witness says, Yes, Your Honor. Court says, we will continue with cross-examination. Miss Abramson says, Thank you, Your Honor. Roger Lee McCarthy, the witness on the stand at the time of the adjournment, resumed the stand and testifies as follows. Ms. Abramson says, Dr. McCarthy, yesterday we were talking about the fact that the illustrations had been changed to reflect the actual measurements that the Beverly Hills Police Department took of the furniture. Do you remember that discussion? He did the diagrams, so she's breaking down all of these diagrams that he created. He says, the 24 diagrams, yes. Yes, we were calling them illustrations here. Okay. And you testified, I believe, that the reason, well, strike that, the illustrations that were created by the computer before that change were relying upon the computer to scale the furniture itself, correct? The witness says the computer is scaling the objects to the images. Yes. All right. And isn't it true that the computer scaling the objects to the images was inaccurate? Not bad. There were just 2 dimensions I recollect that the machine indexed off on, but the rest were pretty good. The table was 48. I didn't ask you pretty good, and I didn't ask you. The court says let the witness finish his answers. Ms. Amerson says we started without Mr. Kessler. So Mr. Kessler for Lyle's team wasn't even in the room. That's interesting. The court says, wait, he was answering the question. Let him finish. The witness says, there were a couple of extended dimensions of the figures that we didn't catch on, but they were pretty accurate, within a ½ inch or so. Do you understand what the word accurate means? Objection, argumentative. Let's ask another question, please. Why? Why? I think that's a relevant question. I asked you if it was accurate, and you went on a tangent about, well, they were pretty good. Okay. Ms. Abramson says, in engineering, isn't it extremely important to have accurate measurements? The field in engineering is called metrology, and the accuracy you need or want generally depends on your application or your bias. Is that correct? Well, your bias cannot affect accuracy. Accuracy is an independent, objective physical measurement. Independent, objective, actual measurement, correct? Correct. All right. The question is, did the computer capture the actual, in fact, size of the furniture before you added the Beverly Hills measurements? Yes or no? And the answer is pretty close. They were a couple dimensions that it didn't. Is that a no? Like, why can't you just answer the question yes or no? It's really annoying when these witnesses do that. Mr. Khan, obviously, because he's Mr. Khan, objects and he says asked and answered argumentative at this point. It has not been asked and answered, but whatever. The court overrules that. The witness says, I don't know how to answer your question differently. There were two dimensions where I would say no. I would say the rest were normal or were within the normal photogeometric reconstructive accuracy. If you tried to recreate this council table and you got two dimensions off of it, you would not have an accurate recreation, would you? That's true, but that would be true. Thank you. The court says, can he finish his answer? The witness says, that would be true because a single table has relatively few dimensions, and if you blew two or four, you wouldn't have a very accurate reconstruction. But if you got into a room where there is multiple dozens of dimensions, and you only miss a couple, that's pretty good in photogeometric terms. We're only talking about the photos, each piece of furniture. Right. But each piece of furniture has multiple dimensions. And the size of the coffee table, length and width were wrong. Width was pretty close. The length was off by 6 inches. 6 inches. 6 inches isn't accurate, is it? Objection, argumentative. Why? I don't understand. It's it's very I don't know what makes it argumentative, to be honest, if that is the case. Um she's not arguing like it's not an argument for her case. 6 inches is not an accurate measurement, right? Just answer the question. But the court says rephrase the question. Ms. Abramson says, is 6 inches off an accurate measurement of a coffee table? No. So that's all. They just wanted her to rephrase it that way, I guess. Now, you testified yesterday, however, that the reason that you re-inputted, or strike that, the reason you inputted the Beverly Hills Police Department measurements was not because the computer was inaccurate, but because you wanted to avoid, I believe you said, another 2 hour flight with me? Another 2 hour fight with me. Is that correct? Is that what you testified to? He did say that. He said, no, I don't. I mean, if you wish to fight, I don't mind, but really what I was hoping to do is, the court says, no, she just asked whether that was your testimony, basically. Why is he helping him out? Like, that was making him kind of look bad, and I wanted to hear the rest of his answer, but the court kind of shut it down, which I don't like he's helping the prosecution almost. The witness says, no, I don't think it was my testimony. I think I testified since we argued over the dimensions for a couple of hours. I wish to remove what I thought was that not relevant issue from the discussion. Ms. Abramson says, and when, Dr. McCarthy, do you claim we argued, you and me, over these dimensions for a couple of hours? Now I'm going to get the term wrong. It's not a preliminary hearing. A pretrial hearing? A pretrial hearing, yes. Dr. McCarthy, do you have a transcript of that pretrial hearing? I have some of it. You only have some of it? Well, I only have some of it because they lent me it this morning, but I didn't get a transcript of it. They, being the prosecutors, Mr. Khan and Ms. Nahira, never provided you with a transcript of those 2 days of testimony. I don't think so, but they would have had I asked, I'm sure. Didn't ask, is that correct? I didn't ask. That's correct. So you have a perfect memory of everything that transpired at that hearing, I take it? No, but Do you have a perfect memory then of what happened between pages 35,608 and 36,613? No. Isn't it true, Dr. McCarthy, that only on those 5 pages is there any discussion at all at that hearing about the size of the furniture and what dimensions the computer scaled it at? Well, that doesn't square with my recollection at all, I mean. Well, you do understand that 5 pages of testimony does not take up 2 hours? That's correct. But then we discussed at the break getting computer downloads, that issue. Well, my recollection is we discussed that issue at some length. Well, let's turn to 35608 if you have it. If not, I will let you see mine. I have 35. No, my copy ends at 35602 and it starts again at 35613. Sorry about that. Here's mine. Your Honor, I am handing the witness pages 35608 through 35613, and I am, although it may be somewhat time consuming, going to ask him to read those 5 pages. The court says, all right, with the court's permission, and the court says, go ahead. He does so. The witness says, okay, there is more discussion of those dimensions than the pages you gave me. Do you want me to continue to read in the transcript or that discussion that you see in there? We're talking about the discussion about scaling the furniture, correct? Yes. And at the point that I gave it to you, we're talking about, at that point in the hearing, we're talking about the distance between the French doors and the back of the couch, not about scaling the furniture, right? I'm sorry, say that again? We're talking at the end of that page, 35613, about how you came up with a distance of 26 inches from the French doors to the back of the couch. Correct. We are no longer talking about the size of the furniture, correct? Well, at the bottom of that page, that is correct. And in that discussion, I was basically asking you what dimensions did the computer come up with for these pieces of furniture? Correct. And you said you didn't have them at your fingertips. They were at your office in Menlo Park. Correct. And the judge, rather than having me go through every single piece of furniture, asked you to provide those dimensions to us, correct? I don't think the judge did. I am reading the transcript now. Perhaps I know I've got your copies now, and I am sorry, ma'am, but I don't read that. Well, let me ask you this. Who also asked you for all the data that had gone into the computer for it to come up with the ability to draw these items of furniture in that way, correct? We discussed that. And the judge eventually indicated that you should provide us with that information on CD-ROM. Mr. Khan says, I would object to that unless the witness was present at the time that the order was issued. Ms. Abramson says, he was on the witness stand at the time. This was at the time you were on the witness stand and I was cross-examining you. The court says he has the transcript. Perhaps you can point him to that. And the witness says, no, the court said something different than that. Ms. Abramson says, let me ask you questions. Can I have my other pages? He says, yeah. We asked you to give us the data printed out, and the court indicated it might be of more benefit to us if you gave it to us on a CD-ROM, correct? No, I think if you read the discussion, I discussed giving it to you in both either printout or in CD-ROM, and the court asked you would it be of benefit to you either way. Go ahead. But I mean, it's 5 pages. Why don't you read the transcript to the jury and they can see the discussion? So the witness is like, you read it to the jury. Now let me tell you what evidence you should put in front of the jury. This witness is something else, trying to control the witness stand. If you haven't noticed, he's like trying to control the conversation, control the witness stand, and Ms. Abramson is having not a hard time, but she is constantly having to bring him back to whatever question she's asking to bring him back to the topic at hand. He's kind of all over the place and he's driving me crazy. She says, I'll decide. Like, I'll decide what I want to put in front of the jury. Uh, I mean, courtroom drama is better than anything on TV, to be honest. Like, TV dramas just don't do it for me. Courtroom, like real courtroom drama, real true crime drama, like, is more interesting to me than made up stuff. Anyways, all right. So the point is, a lot of the discussion doesn't even have to do with my asking you about the size of the furniture. A lot, what's in these 5 pages, is a colloquy about how you're going to get the data to us about what numbers were used to come up with the size of the furniture, correct? Mr. Khan says, I would object as irrelevant, Your Honor, the counsel's 5 pages. Overruled. This is absolutely relevant because he said that they were arguing for 2 hours, and she's like, point me out to that point where in the transcript where we were arguing for 2 hours about this because it doesn't exist. So this is quite relevant, if you ask me. Um, and the court says it is because he overrules it. The witness says, yes, there is a lot of colloquy about it, colloquy about exchanging dimensions and what I was going to do over the lunch hour. Ms. Abramson says, which is, by the way, you were supposed to come up with some numbers over the lunch hour, and you never did that day. Isn't that correct? Objection irrelevant. Overruled. Did you come up with those numbers over the lunch hour? No. There wasn't anybody at my office to print it out, but I also don't remember explicitly agreeing. We discussed the possibility, and I didn't say I would. I said, I think I could. I said I would check into the possibility of it, but the transcript speaks for itself. Wow. Let me ask you this. Ultimately, what was determined in this 5 page entire discussion about the furniture was that you would provide the data and CD-ROM, correct? No, I said I could provide it in some sort of magnetic media or optical media like CD-ROM. I don't know what magnetic or optical media means. What are those? Those terms don't equate, and I'm pretty like technically savvy. I don't know what those mean. And in fact, the following week you did provide it, correct? Not the base data. I think I provided, well, did we send the base data? Did we send the files? Excuse me, who are you talking to? Divender. He said we did send the files. And you sent a magnetic tape also, right? We did. And on that magnetic tape were the new illustrations with the new furniture sizes. Isn't that correct? Mr. Khan says, I would object as calling for speculation unless the witness personally sent the material. Court says, well, let's see if she can establish his personal knowledge. Ms. Abramson says, you previously testified yesterday that it was within a week after the hearing that you changed the dimensions of the furniture to reflect Beverly Hills Police Department measurements, right? That's correct. Mr. Khan says, I would object, Your Honor. May the witness finish his question. What? Okay. The witness says, all for all but 2 dimensions, the changes were extremely minor. Ms. Abrams says, that's not what I asked. I moved to strike that, Your Honor, as non-responsive. Court says it'll remain. And when you sent the data down, the data now sent included the measurements of the Beverly Hills Police Department, correct? Yes. And the illustrations, therefore, were changed somewhat when you sent the data down. To a very minor degree, yes. And is it your contention that even before that week, when you changed the illustrations, you already had the Beverly Hills Police Department data? Mr. Khan says, objection, vague as to time. The court says, did you understand what she is asking you? The witness says, yes. I can't remember. I just can't remember. I'm sorry. Do you remember that the Beverly Hills Police Department measurement data was the third page of the 3 page report indicating the location of all of the items of property found in the room? Yes. And is it your testimony that you had those 3 pages before the hearing, say, of October 2nd and October 3rd? My recollection is that I did, but I cannot tell you for sure. Have you read the transcript of that hearing? No. If I were to tell you that you testified in that hearing that you never had any police report indicating the location of the property found, would that refresh your recollection as to whether you had the data on October 2nd and 3rd? That would be more reliable. Yes. Did I so testify? She can't testify to that, but her question speaks for itself. Turning court and counsel's attention to page 35. I accept it if you say I did. Yes, you did so testify that you didn't have any police report on where the evidence was located. Then I didn't. Have you have you at any time examined the clothing worn by the decedents in this case? Just the shirt of Jose Menendez. And you examined that here in court? No, in the DA's office. And was that in the presence of Dr. Lawrence? Yes. So the ME who testified in this trial, he's not the ME who did the autopsy. He's just testifying to the person who actually did the autopsy. He did testify to Dr. Golden's reports. Golden did the autopsy. And were you pointing anything out on that shirt to Dr. Lawrence? We were pointing things out to each other, so I probably pointed some things out to him. So you and Dr. Lawrence conferred on the shirt before he ever came into this court and testified, is what he says to what he says that he saw on it. Is that right? Let me reread that. That sounded horrible. So you and Dr. Lawrence conferred on the shirt before he ever came in this court and testified to what he says he saw on it. Is that right? We both looked at the shirt together. I don't know if it rises to conferred, but we did view the shirt together when Detective Zoller brought it to the DA's office. And that was before he retook the witness stand and testified to what he claimed he saw on it. Is that right? I think that's true. Now, you're not a fiber expert either, are you, Dr. McCarthy? Not in the forensic evidence sense of what I think you mean, fiber expert, no. Thank you. You never looked at any of the other clothing, correct? Objection asked and answered. The witness says, I don't think so. Ms. Abramson says, you don't know. Well, it's been a year. If Detective Zoller brought the ballistics evidence from the scene, if he were to take the stand and testify, and he also brought a piece of clothing, I mean, he didn't so testify. We're relying on your memory now. I don't recollect ever seeing any, but I am not saying that it wasn't there. I just don't recollect seeing any as I sit here, I think is what he means. Do you recollect ever seeing the white tennis shoe that Mrs. Menendez was wearing? No, not physically, the real. So you saw photographs of them from the scene? Yes. Did you ever see the criminalists' photographs of them taken at the sheriff's department? This is going to sound stupid. Were there any photographs of it on the CD-ROMs I gave you? The court says, let's not ask. The witness says, I'm sorry. I don't have an independent recollection, Your Honor. I'm sorry. Yeah, you're not supposed to be asking the questions, buddy. If you need a clarification about the question itself, that's really the only time you should ask a question. All right. So Mrs. Abramson says, Dr. McCarthy, to the best of your knowledge, the photographs you put on CD-ROM came from two sources, the Beverly Hills Police Department and the coroner's office, correct? Yes. And those are the only sources of photographs you are aware that you received photographs from, correct? Perhaps I was a little too quick in my previous answer. I received my photographs from the district attorney's office. I guess they may have been sent to me directly by the Beverly Hills Police Department, but I don't have an independent recollection of whether I got them from the DA's or Beverly Hills PD. So, what is your understanding about the source of the photographs that you put on CD-ROM? Primarily from the Beverly Hills Police Department and the coroner's office. If the Beverly Hills Police Department film had other agencies' film in it, I wouldn't. It didn't. No? Okay. Objection assumes facts not in evidence, says Mr. Khan. The court says sustained. The remark of counsel is stricken. The answer of the witness to that remark is stricken, which is appropriate because she's testifying and you're not supposed to do that. But she's already done so multiple times and they didn't object. So, whatever. If you don't object, then it can't be sustained. So Ms. Abramson continues. All right, Detective Zoller, if I tell you hypothetically, Detective Zoller has testified that there were Beverly Hills Police Department photographs taken at the autopsy, okay? Do you understand that you have those photographs? That is my understanding. And if Detective Zoller testified that only the Beverly Hills Police Department took photographs at the crime scene, you have those photographs as well. Is that correct? That is my understanding. And if I were to suggest hypothetically that all the rolls of film that you received of that crime scene and that the photographs of the autopsy came from either the Beverly Hills Police Department or the coroner's office, does that comport with your understanding? That comports with my recollection, yes. Now, you do not recall receiving anything directly from the LA County Sheriff's Office, correct? As I sit here, I do not. And you don't recall anyone transmitting material to you with a transmittal letter indicating it came from the LA County Sheriff's Office. And we are talking photographs here. I don't. And no one told you they were sending you photographs from the LA County Sheriff's Office. Is that correct? I don't recollect, or yeah, I don't recollect being told so. Do you remember seeing any photographs of just the tennis shoe? No, feet. Nothing else. No feet. Just the tennis shoe. As I sit here, I don't have a recollection of it, but I would want to check my CD-ROMs to be certain. Well, you provided the defense with a copy of each of your CD-ROMs, correct? Yes. Now, I want to go back for a moment to something earlier in your testimony concerning one of the facilities that failure analysis has. You said that failure analysis has a cadaver laboratory. What is a cadaver laboratory? It's a facility that is set up to do testing on human cadavers. These are people who obviously have died, and there is obviously certain sensitivity and care that must be taken in those situations, so you typically have to construct a laboratory specially to do that type of work. Care and sensitivity. What do you do with these cadavers at the laboratory? Do you shoot things at them? No, typically what we do is accelerate them in our test shed on what's called a buck. We have a system whereby we can put them in the frame like an automotive occupant compartment and then accelerate the cadaver in what's called the buck, the seating area in the interior, stop it with a deceleration pulse that we can program. What is he talking about? We can tell the computer we want the vehicle to ride down like it's hitting a concrete abutment or hitting a soft, small import car or something. We can give it different decel pulse, and then the cadaver, either belted or unbelted, will impact with with the interior. So is he talking about like crash, using them for crash reconstruction or determining damage of human bodies, which he's a mechanical engineer, not a biomechanical engineer. I can't stress that enough. So, what is he doing with bodies, anyways? He doesn't have anything to do with the cadaver laboratory that I know of. He's a mechanical engineer guy. Anyways, so could I stop just for a moment to summarize? You do testing on auto impact on these cadavers, impacts of various kinds of things in a moving vehicle on these cadavers. Is that what you do? In part. Okay. Do you do any tests on these cadavers of ballistics, projectiles hitting them? As I sit here, I can't recollect, but I don't run the laboratory, so I am the wrong person to ask. So you don't know. I do not know. That is correct. You are the chief executive officer of the company that owns and operates this laboratory, are you not? Correct. And you don't know what they're doing over there in Philadelphia with the cadavers? Not the nature of every test. That is correct. Well, when you talked about extreme sensitivity, there is the fact of great deal of sensitivity about people experimenting on other people's dead relatives, isn't there? Well, there is in our shop. I don't know if there is everywhere. So, isn't it important for you to know what is being done to these dead people? Not in terms of the trauma experiences, but how the bodies are handled and how the remains are treated does have to be done carefully. Well, some of the things that's done in these accelerated sheds wind up in decapitating some of these cadavers, doesn't it? Objection, irrelevant. Sustained. At the hearing on October 2nd, on October 3rd, you brought in some of the Fiachi number 4 ammunition that you had purchased in the past year, right? No, I brought in parts of Fiachi ammunition. Well, it was disassembled, correct? But I brought in, no, for instance, no powder. Fine, just answer the fucking question. You know what I'm saying? Like, stop being so difficult. Be like, you just say, yes, I did. However, it was disassembled. There was no powder, but everything else was identical. Like, that's all you had to say. But instead, you make this drawn out thing. Like, no, that's not what I did. Like, you have to fight with the attorney or something. Like, she's trying to get you on every question. She's just asking a simple yes or no question. You know what I'm saying? Like, why do you have to fight everything? This just drives me crazy with these witnesses. And it makes me not give a whole lot of credibility to what they're saying because it's annoying and I tune them out. Anyways, so he says, no powder. She says, fine. And you were testifying, were you not, at some point about the components that make up a load of Fiachi number 4 ammunition? I certainly testified about that topic, yes. Now, I asked you yesterday, did I not, Dr. McCarthy, whether or not it was during that testimony that you first became aware of the fact that the ammunition you had purchased did not match the ammunition used in this case. Do you remember that question? Yes. And you denied it, correct? Correct. Calling court and counsel's attention to page 35727. Do you have that one, Dr. McCarthy? I do. Now, you have up on the witness stand now the items that you were showing me when you were testifying on October 3rd, 1995, do you not? Yes, I do. And we were over this before the jury came in this morning, that what you were showing me, and Your Honor, I'm going to need to mark these, though exactly how I'm not sure. I guess on the white. There is an envelope here that has an empty round of shotgun ammunition and three different, what appears to be paper wads, and a mixture of pellets that appear to be birdshot and buckshot. What's the next in order? The court says 291. Ms. Amerson says, thank you, Your Honor. And I also would like to mark an open shotgun round containing cup powder a shot cup power piston assembly. That's a lot of words in one title. And I'd like to mark that 292, and I am writing it on here, but the witness says doesn't write good. Ms. Abramson says it writes well enough for the purpose. Now, Dr. McCarthy, let me just put these up here so the jury can at least get a bit of a view of what we're talking about. These are the things that you were showing me while I was cross-examining you on October 3rd, correct? Yes. And the envelope, which is now marked 291, contains an empty shot shell casing, correct? Correct. And it has no shot cup inside like this. Correct. It has three paper wads. Yes. So no plastic wad. That's correct. And many mixed pellets of buck and birdshot. Yes. What brand birdshot pellets are in here? I don't recollect what shell I took them off of. So what brand shell did you take the powder? Excuse me, strike that. What brand of ammunition did you take the paper wads out of? My recollection is those came out of a Winchester. And two of these paper wads, well, all three of them are different sizes. Is that correct? Yes. Did all three of them come out of the same round of Winchester, or did the three of them come from three separate rounds? I don't recollect. I just picked up the parts from my bench. Well, is it your understanding that the firearms manufacturers pack varying sizes inside each shell of paper wadding? Different manufacturers use different size waddings in different types of shells. Right. But the same manufacturer could use three different size waddings in one shell. My recollection is that I have seen that. I have seen two different sizes of under wads and one over wad, whatever that is, and all three were different. Is that what this is? Do you know if all three of these came from the same Winchester round? I don't have a specific recollection, so I can't testify to that's being the case. Okay, but this one, which has been marked 292, and the shot cup that's inside of it, this shot cup has what you have called a power piston on it, correct? That's the base, yes. Right, and there is no power piston in this envelope. There is not. Your Honor, I propose to read from 35727 to 35729, line 1, starting at 21. Mr. Khan says, I would object, as Ms. Abramson says. In fact, I could go on reading to 35731. Mr. Khan says, I would object. It's not inconsistent with his testimony. Ms. Abramson says, I believe it is. The court says, all right, well, you have to give it to me and I'll look at it. Ms. Abramson says, excuse me? The court says, you will have to give it to me so I can take a look at it. Mr. Gessler says, or Ms. Abramson says, Mr. Gessler, do you have October 7th to give to the judge? The witness says, I have it here. Ms. Abramson says, no, you should keep it. Mr. Gessler says, October 7th. The court says, the witness is giving it to me. There's a pause. The court says, well, the only part that would be of any value would be 35728, line 15 through 21. Ms. Abramson says, okay, well, I think going over to 35729, line 1, Your Honor. The court says, well, then you're going into a different subject. You're talking about the evidence in the case versus the. Ms. Amerson says, no, we're talking about the power piston that he is showing me. Court says, well, it's not clear to me, so that's all I think is of any value. Ms. Amerson says, well, Your Honor, I don't think it makes any sense if I don't read it all. Court says, I think the rest of it is unclear as to what was being referred to. Why don't you let the evidence come in and let the jury decide? It's so infuriating that we have to keep all these secrets from the jury. Ms. Abramson says, Dr. McCarthy, when you were testifying on October 3rd, were there other people in the courtroom besides you and me? Objection, irrelevant, overruled. Yes. Was Ms. Towery, my co-counsel, at the end of the table there? I think so. Was Mr. Gessler there? Objection, irrelevant, overruled. I think so. Was Mr. Levin there? Objection, irrelevant, overruled. And Ms. Nahira, what was the answer? And Ms. Nahira and Mr. Khan. Yes. And do you remember you were showing me these items that you have just shown the jury and we have just marked, and you indicated that you believed at that time that the number 4 Fiat shot in this case had the same kind of power piston as what you were showing me. You asked me specifically, and I told you no on page 730. You told me at 35729, oh yes, definitely. No, 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 no. That's 5 no's if you're counting. Well, Let me read this to you. This is reading from, I said, but that wasn't the question. Well, let me read you the question. Question: is it your impression that the ones here had the kind of power piston talking about the ones you were showing me? Answer: yeah, I was showing you this one here. Question: right. Is it your impression that the ones here, meaning the evidence in this case, had this kind of power piston, meaning the one that you were showing me, inside the buckshot, meaning the ones you were showing me? Mr. Khan, objection. The court says objection sustained. Ms. Abramson says, what were you answering? Oh, yes, definitely too. You were showing me number 4 Fiachi shot, a shotgun shell. Like the one you're showing me, which I had disassembled. The only reason these wads and shells are here is because I brought them. What? Yes, and that wasn't the question I asked you. Isn't it your understanding that this kind of shell had this kind of power piston in the buckshot? That's what I'm asking you. My understanding was you were asking me about the shell. We didn't have any of the ballistics evidence from the scene. We didn't? Not at the time in front of me during this testimony. This is my recollection. Am I wrong in that? The court says, let's move on, Miss Abramson. The record is really what's on those pages and nothing else. Sir, if she feels like she needs to get into this more, she should have a right to get into this more, but whatever. Miss Abramson says, we'll move on, Your Honor. There were witnesses. Okay, so there were witnesses to the conversations of him saying, yeah, definitely, and now he's backtracking and saying no. Have you seen a diagram drawn by Clark Fogg of the Beverly Hills Police Department indicating measurements taken on October 23rd, 1995, from the French doors to the tree? Yes. Do you have a copy of that? I think so, yes. When did you receive it? In the last couple of weeks. Since you testified in October, correct? Definitely. Why don't you find your copy? I do. I have it in front of me. Let me make sure it's the same one. I believe this has already been marked, Your Honor, hasn't it? The court says, yeah, it's been marked. We did it a couple of days ago. Okay. Court says 278. Ms. Abramson says, so you did not have that diagram at the time that you constructed these illustrations. Is that correct? That's correct. And since receiving it, you haven't changed the illustration. Not a whit. In fact, you haven't changed the illustration based on the testimony of Dr. Lawrence either. Is that correct? That is correct. And Dr. Lawrence has already testified that the diagrams are incorrect. And you haven't changed the illustrations based on anything that you may have received since the week after October 2nd, correct? That's correct. There was no need to. Ms. Abramson says, I move to strike the second half of that answer, Your Honor, as non-responsive. Overruled. That will stand. Ms. Abramson says, now, I believe you started out, Dr. McCarthy, saying that this so-called reconstruction of yours was going to comport with the laws of physics and the laws of thermodynamics. Is that what you said? I could have said that, yes. Is that what you were saying, that these illustrations comply with the laws of physics? Yes. And isn't it one of the laws of physics gravity? It's an effect considered in physics. There is a law of gravitational acceleration. Well, how about the basic law of gravity? That is, on this earth, people don't float. Well, that's not the way it's stated in physics, but there are laws of physics about gravitational acceleration. Well, my question is, are you observing that basic rule that on Earth people don't float unless they're in bodies of water or in liquid with buoyancy? Right. So there is no liquid shown in any of my photographs, not even blood. Do these illustrations comport with a basic notation that people on Earth don't float? Yes or no? Yes. Now, is there anything, or is there another law of physics that has to do with objects? You know, These are sort of simplistic school children type laws, since I am not much of a physics scholar, that two objects can't occupy the same space at the exact same time without coming in contact with each other. They certainly tend to not violate conservation of space. Okay, and there is some basic laws of momentum as well, are there not? That bodies at rest remain at rest unless some force is applied to them. Bodies in motion remain in motion unless gravity or friction or coming into contact with something else stops them. Newtonian laws of classical mechanics, yes, which are valid in most fields. And you have followed those Newtonian laws, correct? There really wasn't any Newtonian mechanics illustrated here, I believe, but to the extent there might be, it should be consistent with that, yes. And have you followed the basic rule in these illustrations that inanimate objects do not move under their own power? I don't know that there is a basic law of physics that says it quite that way, but I don't certainly intend to have inanimate objects move without some sort of input. See, now there was a good answer. Like you questioned her question, but you still gave her an appropriate answer and you didn't fight back. That was a decent answer on his part. I'm not saying it was great, but at least he did answer it. Okay, so if the ways these illustrations were drawn, they keep showing a shift in the positioning of the coffee table. That's an accident? It would be an artifact. I mean, unless there is nothing in my reconstruction that posited the coffee table shifting. What is an artifact? When someone registers an object between frames, he misenters a coordinate or something of that nature, so it would execute a shift in the object, but there was no intention to move the coffee table. Well, are you the one who would do that, who actually put the coffee table in these various illustrations, or did someone else do that? The actual data entry command of the object would be done by one of our graphic persons. So you don't know what these graphics persons intended or didn't intend because you didn't do it? No, it's the opposite. What I intended was to posit the or to position the coffee table, and that was executed by a graphic artist executing the computer diagram. So he didn't even use the CAD program or whatever that did this. Or maybe the diagrams aren't done through CAD, but done through a graphic artist separately and not CAD. So it would definitely make it not accurate if you're not using a sophisticated program with measurements. Um, so if it's just a diagram, yeah, I can see how a graphic artist would not get everything precise. And you have looked at these diagrams since the artist executed them, didn't you? Yes. And didn't you notice the coffee table moves up and moves back? Objection, not in evidence. Overruled. I did not notice that phenomenon. When we go through them, I'll point it out to you. Objection argumentative, motion to strike as that counsel and ask that counsel be admonished. Sustain the counsel or the comment of counsel is stricken. All right. You have small versions of these, do you not? Yes, I do. At the break, I'll ask you to look at them. Okay. Now, when you started out to do this work, Dr. McCarthy, was it your belief that it was an uncontroverted fact in this case that Mr. and Mrs. Menendez were seated on the couch at the time they were first shot? I don't specifically remember my state of mind with regard to that controversy. Okay. Did you testify at the pretrial hearing that you believed that was an uncontroverted fact in this case? The state says they were sitting, the brothers testified that they were standing. Well, I am asking you if you did testify to that, if you remember testifying to that. I don't have a specific recollection of the status of that controversy. Whether there was a controversy or not, you mean? That is correct. So, calling court and counsel's attention to page 35670. By the way, Dr. McCarthy, why are those pages that you said are missing in your copy of the transcript? I haven't a clue. It's not my copy. Why don't you read to refresh your recollection since you have it in front of you, starting at the question on line 19 and go down to line 25. Do you see that? Mm-hmm. And you did testify that the fact that when the shooting began, they, air quotes, they, meaning the decedents, were seated on the couch. You indicated that was one of those things that I didn't think was controverted, correct? Is that what you said? That's not my entire answer. So the prosecution kept that from him, apparently. They didn't give him these pages to refresh his memory on that testimony. And I wonder why, because it's not a good fact for the state. But they should have prepped him so that he knew this was coming. But he says that's not the entire answer. Well, isn't your answer to that question that is your answer to that question, isn't it? No, the answer said you asked me question that is based on your question. If you're going to read it, you have to read it accurately. I'll read it. Mr. Khan says, objection, argumentative, motion to strike. The court says, let's just get to the point here. Ms. Abramson says, I will read it. Question, is that based on this, your hypothesis about how the wounds occurred, or were you given that information that when the shooting began, they were seated on the couch? Answer, that is due to my reconstruction. However, again, that's one of those things that I didn't think was controverted. Isn't that what you said? That was the question, and that was my answer. So you didn't think it was controverted as to whether or not they were seated on the couch when the firings began. Is that correct? Yes, as I testified at that time. And if I understand your testimony from yesterday, at the point when these illustrations were made, that weekend of September 30th and October 1st, you had not had the program set up with the dummies in the computer so that you could manipulate them into various scenarios before that weekend, correct? Before that weekend, yes. So during the week before that weekend, people were inputting whatever was necessary for you to be able to manipulate those dummies and put them in the positions you wanted to put them in, correct? Yes. And over the course of that weekend, you created the 24 illustrations by manipulating the dummies in the frames, correct? Correct. And I take it then you did not have time or for whatever reason try to construct different scenarios by using the dummies on the computer, correct? No, I had the dummies in various positions while I was finalizing these diagrams while I had it in the computer. But you were finalizing what your impressions were at this point, correct? Well, I mean, what my construction was, yes. Exactly. You didn't try to determine if there were any other possibilities. Yes. You were trying to create illustrations of that reconstruction that you had that are determined in your head, correct? More detail, obviously, when you have to create a figure, but yes, generally, that was the progression, correct. So you weren't testing out other hypotheses about positions of the bodies over the weekend, were you? No. You would have taken, or that would have taken a very long time, would it not? Well, it would depend how many hypotheses one tested, but so it could have taken a short time or a long time. But you didn't test any. That is correct. Go ahead. Well, now it is also something that you believe was uncontroverted or accepted that there were 12 rounds fired in this room, correct? Again, at this point, I don't remember my exact state of mind as the function of time on that controversy. My reconstruction requires 12 rounds. Well, you didn't believe that it was uncontroverted that 12 rounds had in fact been fired. At some point in time, I think I believed that, yes. And that's another thing, too, that they never quite proved the 12 rounds. You can't really tell due to the damage, and some might have been caused by others and things like that. So it's really difficult to tell. how many shots there were, and it could have been less than 12. But the state wants to, you know, try to make it as brutal as possible. So trying to, pile on as many shots as possible, basically. So at some point in his recreation, he did believe that there were 12 shots. And do you know what you base that on? It would have to come from the previous trial testimony, and whose testimony? I don't have that specific a recollection. Well, you told us all the names of the people who testified. Dr. Golden certainly didn't testify there were 12 rounds fired, did he? Again, I don't have a specific recollection of getting that impression from a specific witness. That was just, you asked me about my impressions, and that was my impression. Deputy Van Horn didn't testify that there were 12 rounds fired, did he? I can't testify that he did, no. In fact, Deputy Van Horn testified that based on the only available ballistic evidence, the most he, as a ballistic expert, could say was that there was evidence of 8 rounds fired, correct? So keep that name in mind. Deputy Van Horn, 8 rounds fired. He says at most, the most he could say was 8 rounds fired. Mr. Khan says objection, calls for hearsay, sustained. Miss Abramson says you read his testimony, right? Yes, some time ago I did. And you don't remember it anymore. Is that what you're saying? I wouldn't remember, even if, first of all, I don't have a terribly graphic recollection of the context in which he testified. I do remember the number 8 something, but certainly he did testify under oath. I could review the testimony. Well, are you testifying under oath? Well, you are testifying under oath. Didn't you review the testimony? But I didn't characterize the testimony for the jury from memory without going back and looking at it again. So he wants to look at it before he could say with any definitiveness. Well, you didn't take notes about that either, did you? No. Do you not take notes so that you can sit there and say, I don't remember, I don't recall? No. Now then, you don't recall whether or not Deputy Van Horn said there were 12 rounds, or he didn't say that. Objection, irrelevant, sustained. So who else testified concerning the number of rounds fired besides Deputy Van Horn? Objection, irrelevant, sustained. The only question is where he got that figure 12. So Ms. Abramson says, well, he doesn't know. You have no idea where you got that figure of 12? I guess no recollection of where it came up the first time specifically in the previous trial. That is correct. However, I got to 12 in my reconstruction, so it wouldn't matter what the previous reconstruction was. So you got to 12. 12 was wait a minute. You considered 12 the outer limit, didn't you? Oh no, the outer limit is the total number of wounds. Okay, we're going to go through this. You associated certain wounds on Jose's body with each other, correct? Yes. And you associated those wounds on his body that were associated with each other with additional wounds on Mrs. Menendez in one shot. Yes. Well, that's what you call shot number 1. You call it one shot, right? Yes, but I only do that association in one of my shots, is what I mean to say. I'm sorry. Okay. And do you remember when I cross-examined you at the pretrial hearing, I suggested that those might have been separate shots, some of those shots that you associated? I remember we discussed that. And you said, oh no, you would run out of ammunition. Do you remember saying that? I don't remember, but I might have, depending on what we were doing at the time. And if you did, it's because you felt 12 was the outer limit. Could not have been more than 12, correct? Well, You can't do more than 12 without a reload. You've got to go back, and the weapon only holds 6, so you would run out of ammunition without going into a reload. But you can buy infinite numbers of shells. But you knew, Dr. McCarthy, did you not, that there was testimony from Erik and Lyle Menendez at the previous trial that there was a reload? Objection, irrelevant. Overruled. Well, yes, but in the preliminary hearing, you and I were arguing about about the reload and whether or not one occurred. Dr. McCarthy, I wasn't arguing, I was asking questions, just like I am now. Do you call this arguing? No, but we had a very much more animated discussion in the preliminary hearing. Pre-trial? I'm sorry, I do that wrong every time. The pre-trial, but you can only put 6 rounds in each weapon, so after 12 you are out of ammunition unless you reload. All right, and you accept the fact that there was testimony at the previous trial that there was a reload. Objection, irrelevant. Wait for the purpose The court says, wait for the purpose of you're preparing those diagrams. Oh, wait, sorry. The court says, wait, period. For the purpose of your preparing those diagrams and your reconstruction, did you assume there was reloading of shotguns? The witness says, no. You asked me that question at the preliminary hearing, pre-trial, and I indicated there was nothing in my scenario that required a reload. We discussed that specifically. We are not talking about required. This is a real event that happened, not just your scenario, correct? Objection, argumentative. Rephrase the question. Isn't this a real event, not just your scenario? Again, I would object. It is unclear what you mean by that. There really was a shooting of these 2 people, correct? Correct. And there is no question that Erik and Lyle Menendez did it, correct? My understanding is that is not controverted. Well, they testified to that, and you read their testimony, right? Objection calls for hearsay and irrelevant. How is that irrelevant, reading the defendant's testimony? Overruled. Yes, I did. But the reason I stated the question that way is a couple of other things that I thought were testified about and weren't controverted, you have since asked me about. And so I didn't ask you if it was controverted. Mr. Khan says, objection, Your Honor. May the witness finish his answer. Court says, all right, I think he has answered the question, or I think he has answered the question. Let's get to the next question. Ms. Abramson says, the issue is you read their testimony. They discussed the fact that they went into the room and they did the shooting, and you read that, correct? Objection calls for hearsay and irrelevant. Overruled. You may answer the question. I'm getting annoyed with Mr. Khan here. The witness says, I think that specific description was in the trial testimony I read. Unfortunately, I have read a lot of stuff since I have read the trial testimony, but I think that's in the pages that I had indicated to you I read as well. So you don't know if what you were given by way of the testimony of Erik and Lyle Menendez was their testimony about the shooting. You don't know that. I think it was. That is my recollection, but so you think it, you don't know. Well, I don't think. I know that is my recollection. But again, before I am not comfortable about testifying about the specific contents of someone else's sworn testimony under oath. And so before the jury accepts my representations, I would read the transcript so I could be certain. Ms. Abramson says, move to strike that as non-responsive. Overruled. Whatever. This judge is so biased. Ms. Abramson says, you have read the testimony. That's what you told us, right? Yes, but it's been a while since I read it. And you didn't reread it to prepare to testify here. That's correct. However, reading that testimony without getting into the specifics, what you read was Erik and Lyle's what you read was Erik and Lyle say that they did this shooting. Yes, that is my testimony. That is my recollection. So there is no controversy about that, right? Objection calls for conclusion on the part of the witness. Sustained. Is that where you formed the opinion that there was no controversy about the fact that they are the ones who did this? That is my recollection, yes. And they also testified in the same pages of the transcript which were with which you were furnished that there was a reloading, didn't they? That is my recollection. I just, again, my understanding or my standing discomfort about someone relying on my recollection of testimony. That is correct. And did you reject that testimony that there was a reloading? No, nor could I. Excuse me, nor could I independently confirm it. But it's a factual record, is it not? For your reconstruction, what people say they did is a source of factual information, is it not? But they have said what they did several different ways, which are in complete conflict. In the transcript that you read, I can't say that there was conflict in the transcript I read, but what they have said they did at various points in time, it is my understanding, is not controverted conflicts. Wait a minute, you're talking about statements that they made outside of trial. No, I am talking. Tell me what you were talking about. What statements of the defendants uh, where they talked about this shooting are in conflict with what you read in their testimony at the previous trial? Objection irrelevant. It calls for hearsay. The court says, all right, let's take a recess and we will resume at 20 minutes to the hour. Wow. Way to save the witness. Don't discuss this matter with anyone. Don't form any final opinions about it. We will resume in 20 minutes. I'm going to keep going because I want to keep going. The court says, excuse me, I need a sip of water to do so. So wait just a second. All right, so they went on break. The court says, all right, the jury has left the courtroom. So now this is outside the presence of the jury. We're going to have some arguments, it appears. All right, so the court uh, says there has been an objection to the last question. What is it that you intend to elicit from the witness? Miss Abramson says, well, I have no idea, Your Honor. This witness, I asked him what he was submitted, and what he has submitted, and now apparently he is making up opinions and conclusions based on what he reads in the newspaper. So I don't know what he was going to say. The court says, well, there's no information or testimony from the witness that he considered these and that they formed a basis of his reconstruction. And what you, Ms. Abramson says, well, Your Honor, the court says potentially depending upon what the witness says, you could bring in all sorts of things that he has read about, statements made by the defendants to others that were introduced in the first trial that the jury has not heard. Ms. Abramson says he hasn't read those. The court says, I don't know that. Ms. Abramson says, well, he told us what he had. Court says, you're certainly opening the door to anything. Ms. Abramson said, I would like to excuse the witness, Your Honor. He already knows how to play the game. Ooh, that was a good one by Leslie. The court says, counsel, let's not make these catty remarks. It's appropriate for counsel to do that. Ms. Abramson said, I would like the witness excused. Court says, you can wait outside. Oh, I love Miss Abramson. She's awesome. She's not afraid to say the catty stuff. She's like, he knows how to play the game. Get him out of here. He knows what he's doing. He knows that he's purposely evasive and not answering my questions. So let's not give him more information to give him ammo for his very evasive and deceitful testimony. All right, Ms. Abramson says, and then I would like to be heard about what I think is happening here. The witness leaves the courtroom. The court says yes. Ms. Abramson says, well, Your Honor, he has testified both here and at the pretrial hearing. First, let's go back to the pretrial hearing. He testified there that he believed 12 was uncontroverted, and that was based on the fact that the defendants had testified they bought one box, and what he has done is he selectively relies on their testimony when it supports his theory. but that denies that he is relying on it. And obviously, he is saying that because the prosecution does not want to let us ask him specific questions about specific aspects of our client's prior testimony. As you can see, because he's throwing objections like like there's no tomorrow. It's very clear this is a tactical game, and he tried to play it at the pretrial hearing as well. However, at the pretrial hearing, towards the end, he was admitting that he relied on their testimony with respect to establishing a reload, that he relied on their testimony with respect to establishing that it was they who did the shooting. And our position is he cannot selectively rely on their parts that support his theory and discard the others, or prevent us from inquiring about the others just by saying, I didn't rely on that. This isn't the standard kind of expert opinion where they're relying on a text or on some other expertise or some other authority. And I understand the rule is when an expert has not relied on a text, then you can't bring that hearsay or that hearsay text in. But this is someone who is claiming to reconstruct a crime, who claims to have a factual basis for that reconstruction, who has indicated what material was submitted to him in order to do this reconstruction. I don't believe that he can be allowed to claim that well, if he wants to say he completely ignored the testimony of the defendants, fine, let him say that, but he hasn't said that. If he has relied on any part of it or considered any part of it, I think we should be able to go into what it is that he heard, what it is that he relied on, what it is that he's ignoring to show what we believe his very strong and very obvious non independent bias that is not an objective witness. And so I think we have a right to go into that. Now, what he is saying about other things, he is obviously being cute and trying to rely on statements. The fact that the defendant did not automatically admit that they did this shooting and trying to go outside the questions I am asking and being non responsive. I'm only talking about what was in the transcript. He is relying he is trying to bring these other things in, and he should be admonished not to. The court says, well, the nature of your questions were such that it certainly created the potential of him volunteering anything in the world. Excuse me, sir? The nature of your questions were such that it certainly created the potential of him volunteering anything in the world that he might have heard about the defendants or their statements to anybody. Ms. Abramson says, court says, let me finish. What you are basically proposing is to go through the defendant's testimony from the first trial and ask him, did he consider this? Did he consider that? And bringing all sorts of things before the jury. Ms. Abramson says, no. The court says that he didn't consider when it seems to me that if you ask him what he considered and his testimony is that he considered the fact that there was a reload of the shotguns and nothing else, then that's all that was considered. Ms. Abramson says, well, I don't know that there's many other details I haven't asked him about, but I don't. The court says, what you're proposing to go through is everything. Ms. Abramson says, no, I am not, Your Honor. I don't intend to go through everything. I can assure the court that there are only a few crucial facts that I intend to ask him that he considered, and if he says no, I want it clear on the record that he chose to ignore certain parts of the defendant's testimony while accepting the parts that helped him. She should absolutely be able to do that. That is impeachment 101. That's credibility 101 for witnesses, especially experts. And that's the point I am trying to make. And I don't intend to make or to take him through everything, a few things, just as I did at the pretrial hearing. Things concerning the lighting conditions, things concerning firing all the shots in the gun, for example, which he himself is relying on because he has talked about the gun having a 6-shot capacity and therefore all 6 shots had to be fired. The court says, well, it seems to me that that's the issue, whether or not he relied upon the testimony from the first trial as to the number of shots fired. But everything else, as far as lighting conditions and things like that, is irrelevant unless you're going to ask him for opinions about whether the people doing the shooting were capable of aiming the shotgun at certain individuals and things of that nature. Really? The court says, well, If you do that, you're going into other areas that haven't been brought out in direct examination. Ms. Abramson says, I know, Your Honor, I do think it goes to, just as the court indicated at the pretrial hearing, I think that the wildness of the opinions that he expressed in his report and in his interview goes to his credibility as a so called expert witness. The court says, yeah, I'm not disputing that or addressing that issue. What I am talking about, though, is that from what I have heard, the only significant fact that he considered was that there was a reload of the shotguns, and from his testimony so far, that doesn't even seem to be significant. It only explains why perhaps there were different rounds of ammunition fired, but it doesn't need to be explained that way. So at this point, I am going to sustain the objection because, oh, big surprise, because we were going to into hearsay material. Ms. Abramson says, then I would move to strike his last answer where he volunteered, or the last two answers where he was volunteering other statements when there were no other statements of the defendants ever describing the shooting except what they testified to. The court says, oh, there are other statements, the statements made to Signorelli by your client. Ms. Abramson says that doesn't describe the shooting. The court says it describes the nature of the entrance into the room and things of that nature, which door they came through and what happened. There are other statements. Ms. Abramson says he hasn't seen these statements. Court says we don't know that. I would like to question him outside the presence. The court says that is a whole other area, one that needs to be gone into, one that needs to be gone into because it goes into extraneous material. Ms. Abramson says, then we should strike the answer he gave. Otherwise, and the jury should be admonished to ignore it. Otherwise, it says he knows of some other statements the defendants made having to do with the specifics of the shooting about other rounds fired and whether or not there was a reload, which is what I asked him. Mr. Gessler says that's exactly before the jury, Your Honor, and he listed before the jury yesterday what he had reviewed. It wasn't Signorelli's statement or the testimony of Lyle and Erik before the jury. That's right, he did list what he referred to. Court says, okay, you find where it was in today's transcript or yesterday's transcript, rather, what the actual questions were. It's difficult to say the last two questions and answers because that might not be exactly what it is. Ms. Abramson says, I will ask the reporter. Court says, and I'll be glad to deal with it. Ms. Abramson says, I will ask the reporter during the break. Mr. Gessler says, you said yesterday's transcript, Your Honor. The court says, you said yesterday. Mr. Gessler says, for what he relied on, yes, not for the answers to be stricken. The court says, well, then today's transcript, as far as the actual answers and questions. Ms. Abramson says, right now. The court says, you can do that. Okay, we will be in a 20-minute recess. Recess was taken, and that's where I'm going to end it for today. Thank you guys so much for tuning in and following along with this trial with me. I know it's a long one and there's a lot still more to go through, but it's going to get more interesting, I swear. Once we get into the defense's case, I'm sure things will get a little more interesting and more palatable. This boring science stuff, I don't know. Some science stuff is boring to me. Although the physics and stuff in the Karen Reed trial, the ARCA guys made it really interesting and but he's more like a welcher. If you watch the Karen Reed trial, this guy's more like a welcher. He doesn't want to answer the questions. His information is wrong. His data is incorrect. You know, the diagrams that he's bringing to the table are incorrect. He's a welcher or Shannon Burgess with one N, um, from trial one of Karen Reed. So I can't wait to see who the expert is to refute this on the defense's side. I bet they'll be a little more easier to follow because this guy kind of sucks. So that's where I leave you guys today. Thank you guys for watching. Please don't forget to hit the like button, subscribe, comment, let me know what you guys think, and I will see you guys in the next one. Take care. Bye now.